This week's topic is correspondence. As you can see on the slide, there are 5 questions that you should turn your mind to before you begin the planning process or attempt drafting the letter. The first 3 questions apply regardless of whether you are writing to your client, your opponent, or a third party. The first question is there to focus your attention on the reason why you're writing to that recipient, to ensure that you only include content that is necessary for that purpose. The second question focuses on the recipient. What are the needs of that recipient? The needs of your client in reading a letter are likely to be very different to your opponent who is a practicing lawyer. The third question, what matters must be addressed in the correspondence, is really targeted towards the context. So, for example, with a client, what background information do they need in order to be able to understand the advice that you provide in the letter? The fourth question, which focuses on the structure, is very important where you have more than one matter that you need to address in the letter. This draws your attention not only to the fact that you need to include headings so that it flags to the reader each time you move on to a new issue or a new matter, but also is designed to focus your attention on what is the most logical order to deal with the matters that must be addressed in that correspondence. The fifth question focuses on letters to third parties and your opponent. You must always consider your client's instructions when drafting those letters. Failure to comply with your client's instructions may give rise to a complaint or have negative practical consequences for your client's case. So why is it important to consider the purpose, audience, and context when drafting any letter? The purpose, context, and audience will shape the letter in terms of its content and its tone. So let me give you an example. Sometimes letters are merely informative. They're designed to tell someone that they must attend court on a particular date or to note receipt of documentation. In those instances, that context and purpose will mean that the letter is short and to the point. It certainly won't attempt to persuade anyone of anything. Letters can also be a request that the reader undertake a particular action or a request that they refrain from doing something. An example might be requesting that a client complete and return a form. Again, that will shape the content of the letter. It will be short and to the point. Note that in contrast, a letter that attempts to be persuasive, for example, an offer to settle, may include persuasive language. It will be much longer. It will include persuasive language designed to strongly assert the client's position and convince the other party that it's sensible for them to accept the terms proposed. And of course, if a letter is designed to provide advice to a client, then again, that will shape the content and tone of the letter. But also in that instance, the audience is really important too. You must bear in mind that a client has no legal knowledge or very little legal knowledge and therefore won't understand reference to legal terms or legal jargon. That client will need the law explaining to them. You can't assume that they know anything about that particular area of law or the relevant court procedures. If you contrast that with where the recipient is a member of the legal profession, you can assume that they know the relevant court procedures that you're talking about. So as you can see on the slide, there's a basic structure for a letter, and it really doesn't matter whether you're writing to your client, your opponent, or a third party. It still takes this standard structure. Now, the reading for this week and the study guides go through each of those particular sections of the letter in more detail, but I just wanted to emphasize that the introductory paragraph and the penultimate paragraph are very important. It's really important to identify to the reader at the outset why you are writing to them. So this should be a short statement indicating what you require from them or what you want them to do or the purpose of writing. And that should be mirrored in the penultimate paragraph. That's important because, of course, you need to remind them at the end, after they've digested the body of the letter, what you require them to do or what your purpose for writing was. Note that in addition to identifying the reason for writing, if you are writing a letter in response to correspondence you have received from someone, that should also be noted in the introductory paragraph. And the reason for that is because it articulates to the reader that this is a reply and response, and it also helps in terms of identifying the chronology of the exchange of correspondence between the parties. So when providing advice to clients in a letter, you need to remain objective in the way that you deliver the advice. You identify if there's a range of potential things that might happen because, say, the law is ambiguous or it's not clear whether the evidence supports their case. You'd need to identify the range of potential things that may happen and then say which is the most likely and why. Once you've given them your reasoning on that, you also need to provide them with practical advice. So what does that mean for them? Should they continue with their litigation? Should they make an offer to settle? Should there be more investigation and more gathering of evidence? Or should they attempt to mediate with the other party? So that practical advice is just as important as the legal advice. So when drafting that letter to your client, you need to explain the law simply and concisely. Where possible, avoid going into great detail about the law, and certainly don't quote large sections of text from a case or a statute. Instead, provide them with a summary of the law that is explained in terms that they can understand. You really need to help them navigate through the law rather than trying to teach them what the law is. Really, you're there to deliver a brief summary of the law and get to the point of the letter, which is to deliver advice as to what they should do next. Now, moving on to huge big warning signs here. Whenever you reveal information about your client in a letter to another, whether that's an expert instructed in the proceedings or your opponent or a third party, you must ensure that you do not reveal confidential information unless you have clear instructions from your client that you are permitted to do so. Remember also that you can weaken your own case by providing the other side with information that they currently don't have access to. So it comes back to focusing on what is the purpose of this correspondence. What am I trying to achieve with this letter, and what is the minimum amount of information that I can reveal to achieve that particular purpose? Now, the study guide has a section dealing with confidentiality and also without prejudice correspondence. It's really important that you go through that so that you have a basic understanding of how that operates in practice, and that we don't just rubber stamp everything with without prejudice, because that means that we then can't rely on that letter in subsequent litigation when we might actually want to use it as evidence. There are a range of ethical considerations that must be at the forefront of your mind when you're writing to your opponent. For example, Rule 22 of the Australian Solicitors' Conduct Rules states that a solicitor must not knowingly make a false statement to an opponent. In fact, it's a really good idea to get hold of the Solicitors' Conduct Rules so that you can review them for yourself and make yourself more familiar with the range of ethical requirements.